Roll call of supervisors, please. I know Supervisor Haas left a message with me that he wasn't going to be here tonight. He's not feeling well. Supervisor Underhill is working, and Supervisor Grulich is also absent. 25 in attendance. Citizen comments. At this stage of the meeting, we'll open up the meeting to citizen comments. If you'd like to address the board, please approach the microphone. Name, address, speak loudly and clearly, Mr. Gens, if you would.
Thank you, Mr. Chairman. Virgil Gens, 16906 38th Street, Kenosha, Wisconsin, 53144 in the town of Paris. Tonight, there was a certain celebration, and Mr. Velopentesta, Frank Velopentesta, retired. Just a few comments I'd like to make about Mr. Velopentesta and my 33 years in working with Frank on different issues and so forth, and I'm going to read it just the way that Frank wrote it, okay? No, not at all. Not at all. Not at all. I learned to come to appreciate Frank and the things that he has done for us in the town of Paris and for people in Kenosha County that maybe a lot of people just don't realize. And of course, I think some of the things, issues that come through zoning, planning and zoning, and when there's difference of opinions, and Frank's had to work on a number of those projects, not only for the town of Paris, but for all people in Kenosha County. Thank you, Frank. Smart growth. I'm not sure if I'd call it that all the time, but that's a mandate that we have from the state, and we worked very hard at it. And along with help from Frank's office and Frank attending meetings, some things got accomplished. Thank you once again, Frank. And of course, we know that there's a landfill in the town of Paris, and in working together, we know that garbage isn't coming at the landfill at the rate that it once did. And those in Kenosha County, you people living outside of Paris, you have suffered some dollars and cents, and we in the town of Paris have suffered a lot of dollars and cents. But in working together on this particular contract, I know Frank put a lot of hours in for the county, and thank you, Frank. We do appreciate it. And as a person that's known Frank for these years, approximately, well, going on 34 years on the board, thank you, Frank, for the effort and time you put in, and not only for us, but for Kenosha County. A lot of things behind the scenes that we don't really realize go on in that office. And thank you once again, Frank. And my last comment would be, I don't know if you folks know that, but Frank, you know, he is buying property in the south, and he's moving south, and he's going from Holy Hill to just across from the lighthouse here in Kenosha. Now he wants to get where in the warmer climate, but happy retirement, Frank, and thank you, Mr. Chairman.
Thank you. Virgil, I also have grown rather tiresome. I mean, appreciative of Frank as well. So, any other citizen comments? Any other citizen comments? Seeing none, citizen comments are closed. Well, I do not have any announcements of the chairman this evening, although it probably seems the appropriate time to offer the microphone to one Mr. Velopentesta, if I'm not mistaken. Frank, would you like to add anything to Mr. Gens's announcement?
I'd like to thank Verge. I've had the opportunity to work with all of the county officials and the town officials, village officials throughout the years. It's been a very wonderful experience for me. As I said earlier, I was given an opportunity with this job to do everything from assessing to zoning, broadband, child abuse. We've handled it all in the office, workers' comp, all of these different areas of the law. Probably didn't become an expert in any particular one, but knew a little bit about everything at the end of the day. So, Verge, I want to thank you and the people of Paris, and I want to wish everyone here the very best. I have special thanks for my staff. We were talking tonight about how long some of the people have been with me in the office. They are not people who work for me. We have all worked together as a team and have been able to accomplish a lot of things. I think that we will. There's a rule in Kenosha, it's called the Kenosha rule, and the way it works is like this. If any of you don't know it, this is what goes around comes around. And And former Supervisor Pitts has something to look forward to. In any event, as I was saying, I did have the opportunity to work with some very wonderful people in the office throughout the years. I had their support. Linda and Lynn, Bernie, who's been with the office for, I think, 30 years, Linda for 35. They have been very good people to work with throughout all of those years. Kenosha has always been a special place for me, not only because I met my wife here, but as I said earlier this evening, when I first came to Kenosha, they not only told me that, they not only pronounced my name correctly, but they told me that I was spelling it wrong. So I have had an opportunity to reassociate myself with my roots and my ancestors from southern Italy. That's been something that's been very special to me. It's something that I encourage everybody to do, no matter what your ethnic background is. I can remember when I took my dad back to his hometown in Calabria, old man came up to us and said, "Where do you work? Or where are you from?" And I said, "Well, Chicago, near Chicago," I said. And he said, "Well, where near?" And I said, "Well, in Wisconsin." He said, "Well, where in Wisconsin?" I said, "Kenosha." And he looked at me and he said, "Kenosha?" And he ran away as fast as he could. And about 20 minutes later, I saw him in the distance. He was running. I thought he was going to have a heart attack. And he handed me a picture of the Kenosha County Courthouse, which at that point on my vacation was the last place I wanted to see. So there's been a real connection here between me and that segment of the community here. I had the opportunity to, as I said, work with an awful lot of officials throughout the years. I remember a lot of them. A lot of them became personal friends. Franny Pitts, Earl Hollister, Dick Lindgren, and I could go on and on. I think Ron Frederick is probably one of the few that started with me back in the early 70s, which is something that I would say, you know, when I look back over those years, I can look at it with a little bit different perspective, I think, than a lot of people. Sometimes I think the board may forget or be a little hard on itself, but you've done an awful lot over 40 years. I was talking to Cindy Johnson from the health department. I said, I remember when the health department was a closet. I remember when zoning was not much more than one small room with a few maps. In our office, basically 2 small offices and a reception area. So you have done a lot, and it's been through the efforts of this county board and through the efforts of all of the officials that preceded you. I had the opportunity to work with with all of the county executives. I tried to learn from all of them in some form or another, and especially the employees. I had the opportunity to negotiate at the bargaining table with these employees. They were always professional. I always enjoyed working with them. They're in your front lines and in your front line trenches doing a lot of things that a lot of people don't realize they're doing, and clearly an asset to this community. So with that, I was quite surprised tonight. I thought I could leave quietly, but that wasn't going to happen, I guess. So I'm trying to bribe Joe Patenti to putting this in somewhere in the classified section of the newspaper tomorrow, if I could. And with that, I just want to say thank you, and I do need to keep coming down here. My dentist is here, and so is Tanuta's, and I plan on visiting them quite a bit. Thank you again.
Frank, I'll need you to join me down front, as is somewhat customary, and I'll ask the county executive to come up as well. It occurred to me as you were talking, Frank, that as any middle schooler, maybe high schooler, thinks of his teacher when they have them in class, my gosh, how long has this individual been teaching, right? They're all ancient when you get there, and certainly elementary school and middle school. So it occurred to me that you have been here, or I've been here, depending how you want to look at it, for nearly half of your career. And geez, I thought you were retirement age then. This official proclamation was read earlier this evening at Frank's surprise party, and it truly was a surprise, and the credit goes to the county executive and Jenny and all of their staff for pulling that off. I was just along for the ride. I will have a few more comments, no doubt, as I go through this, because I find it all rather fascinating. So for those who were there, I'll ask your indulgence. For those who weren't, I think you'll find this somewhat enjoyable. Official proclamation by the County Executive and County Board of Supervisors of Kenosha County, Wisconsin, Frank Volpin-Testa Day. Who'd have thought? Whereas we gather here today to honor Frank Volpin-Testa, who is about to conclude a distinguished career as Kenosha County Corporation Counsel after loyally serving Kenosha County for over 40 years. And whereas it has been said that Frank earned his law degree from Marquette Law School in 1971, again, I'll comment I was 6 then, by copying the Honorable Wilbur W. Warren's assignments, who was his classmate. Frank claims the opposite, as one might imagine. And whereas Frank began his career with Kenosha County on September 2nd, 1971 as Assistant Corporation Counsel and was appointed Acting Corporation Counsel on June 7th, 1977. Again, you should point out it took 6 years for them to be comfortable with having you in the position. I wouldn't read too much into it. Whereas after being coaxed by former County Board Supervisor Wayne Kessel, Frank applied for the permanent Corporation Counsel position and was officially appointed in about August of 1978. And whereas Frank's challenges as Corporation Counsel included the change to a county executive form of government, Gil Dozmegan says hello, by the way, drafting and defending the comprehensive zoning ordinance, drafting the ethics code, and any IGA involving the city, and moving his office 5 times, most recently from the Yule House to the courthouse garden level, as it's become affectionately known. And whereas Frank, this is where it gets good, Frank will be remembered for his very competent and sound legal advice. I can't say that every time I was there, but we'll go with sound and competent for the time being. His sense of humor, I got to say once in a while that came out, and his refusal to convert from WordPerfect to Microsoft Word. And that is the God's honest truth. There is no question. He will be dearly missed by all who have had the pleasure of working with him. Now, therefore, we, Jim Cruiser, Kenosha County Executive, and Mark Molinaro, Jr., Kenosha County Board Chairman, together with the Kenosha County Board of Supervisors, do hereby proclaim Tuesday, March 6, 2012, in the daylight is fleeting, as Frank Volpin-Testa Day in the County of Kenosha, and we urge the citizens of Kenosha County to show their appreciation to Frank Volpin-Testa for his many years of dedicated service and his immeasurable contributions to our community. We wish him good health, continued success, and happiness in his retirement, given the 6th day of March 2012. Jim Cruiser, County Executive, Mark Molinaro, County Board Chairman. Frank. It has truly been a pleasure to work with you. I think, I started my first term on the county board. I believe I was on the legislative committee at the time. If it wasn't the first term, it was shortly thereafter. I've always appreciated your input, your guidance. I think you've served Kenosha County well. You've certainly served the county board well. You have served me well over my time here on the board and currently as county board chairman. I appreciate it. I wish you nothing but good health and success in the future, and thank you very much for everything you've done.
Appreciate it very much.
You get a little more, Frank.
All right.
But I just have to tell you, I worked with Frank in my first round in county government, and now again. And I will tell you, a lot of the successes that we've had in the last 40 years is because of sound legal work from your team in your office. Sometimes you deliberately went a little slower, so we got it right, but that was good. That's a good thing. Make sure we got it right. You saved the taxpayers hundreds of thousands of dollars in outside legal counsel by doing many of these jobs in-house, taking a little longer, but you're very conscientious. And Frank's one of these people, like many of you are. However, I know Frank gets called on the weekends, because I would call him if there's an issue in my head. He's thinking about public policy and issues that are in front of us on the weekends. And I know he doesn't work by the hour, he works by the calendar. And he definitely puts the hours in, and over the last 4 years, we've had a lot of hours together. And a lot of the successes that have happened since I've been here as county exec has not only been because of the county board, but it's also because of the great advice we have with Frank Volpentesta. And I appreciate your work ethic, and you as a friend. So with that, I'd like to give you a County of Kenosha Frank Volpentesta in recognition of 40 years of dedicated service on behalf of the citizens of Kenosha County, September 1971 to April 2012, presented with the deepest respect and affection by your colleagues and friends at Kenosha County. Frank, no one's going to fill your shoes, but I want to tell you, we are going to miss you, and you're always welcome around. I know you're going to be back.
I'll be back. Jim, Mark, again, thank you very much. I appreciate your thoughts and all of your comments. I hope Word Perfect does also. But that's just one example of the understanding that I've been given here with the county. And there have been so many other things that have happened that they're just too numerous. But I do think about you a lot, and you're in my thoughts and prayers, all of you. And I do hope to see you again.
Very good. Thank you, Frank.
So moved. Point.
Thank you, Mr. Chairman. I would like to make a motion, put it on the county board floor, making a motion to thank Frank Volpentesta for all of his years' service, being officially recognized by the county board.
I'll recognize. Moved by Zerban. Is there a second? Second. Seconded by the county board as a whole. All those in favor signify by
Roll
saying
call.
aye. Roll call request. Beam plus if you're in favor. And that is the only option this evening. Hold on, I think reconsideration, I understand. One more. Frank? Frank, did you vote? Yes. Fred. There we go, 25-0. Again, Frank, thank you very much. Supervisor reports. Any supervisor wishing to make a report?
For you, Dennis.
Supervisor Brunig.
Thank you, Mr. Chairman. I was just commenting to Supervisor Alverman that I hit my button before he did this time. So he's getting old, yes. Just a quick report. Extension Education will be meeting next Wednesday, March 14th. We, on our agenda is a short discussion about the combination of the committees. If anyone wants to come and voice their opinion on it, that would be the time. I hope to bring that information back to the executive committee and then probably meet as a committee of the whole, which is in the resolution. Also on March 28th and 29th, Extension will be having their youth and governance interviews. We hope to come back with a whole bunch of new youth to sit on our committees. Thank you.
Thank you. Supervisor Elverman.
Thank you, Mr. Chairman. Briefly from Facilities and Public Works, most of the construction projects that I've mentioned over the previous months are all wrapped up or wrapping up, and most of them just need some spring work as far as landscaping. Just going to hit a couple other minor things that have come up. Our towers, communication towers, are in need of some assistance. We've had some studies done, and nothing that's immediate, but our 60th Street tower is a tower that is probably going to have to be replaced. Our Highway 50 and 45 tower needs some reconstruction. Remarkably, the old one at Highway B, the old Silver Lake Highway Garage, is the only one that needs nothing. So that's something that's going to be coming to the board from our committee. Signs for the dog parks, I've been asked about that since that's been a year and a half or so. They're in the shop. The designs have been picked by the families, and those should be up shortly. Golf division, the two golf shows, the two major golf shows in this area, the Chicago and Milwaukee, were attended by our staff. We had a booth. We gave out numerous promotions. We had a lot of interest. They had some drawings for free golf passes. So I believe they had 6,500 contacts. So we're looking at that as a positive sign for the spring for golf. And that's all I'm going to report on this evening. Thank you, Mr. Chairman.
Thank you. Supervisor O'Day.
Thank you, Chairman Molinaro. On your desk, you'll find a Brookside Care closeout report. It's revised March 5th. So if anybody has any questions on it, they can talk to me about it and or see and talk to Lori Staves about it. The other thing at the meeting yesterday, we're going to be looking into putting an LED sign out on the front in addition to the sign that Brookside has now. And it's not going to come out of taxpayer, it's going to come out of the trust fund that we have. But we're just in the investigation stage right now. But we think it'll be a nice addition because it'll be able to be changed on a computer remotely. And it'll have any events going on. It'll talk about the rehab center that we have and anything else that Brookside comes up with, any event that they have. So, thank you.
Thank you. Any other supervisor reports? Seeing none.
Ordinance, second reading to required. 16, from Supervisor Rose and Public Works Facilities Committee, an ordinance to amend Chapter 10 of the Municipal Code of Kenosha County entitled County Parks. Submitted by Supervisors Rose, Elverman, Grady, Gale Gentz, Boyd Frederick, Esposito, and Colmeyer.
Supervisor Elverman.
Thank you, Mr. Chairman. I move Resolution 16.
Resolution 16 moved by Elverman, seconded by Supervisor Rose. Supervisor Elverman.
I'd like to defer to Supervisor Rose.
I'm sorry, ordinance. Ordinance 16. Go ahead. All right, defer to Supervisor Rose. Supervisor Rose.
All right, thank you, Mr. Chairman. Ordinance number 16 before you is an amendment to the existing park ordinance. It clarifies for everyone that if you're going to express your right to freedom of speech by using a sign, a banner, a picket, or any other items to express your free speech message, you don't need a permit. The ordinance does not change the permit process if you're going to have a public meeting, a public assemblage, such as a country thunder or a some other kind of public meeting where there are going to be a good many people. But for the individual who wants to express themselves on any kind of public issue that they're interested in, the ordinance makes very clear that no permit is required. This was drafted by myself and Assistant Corporation Counsel Bernard Vash.
Thank you. Any discussion on Ordinance 16? Seeing no lights. All those in favor? Roll call requested. P and plus if you're in favor of Ordinance 16, P and minus if you're opposed. Supervisor. There we go. Motion carries 25-0.
17, from the Executive Committee, an ordinance to amend Section 2.08 sub 4 of the Municipal Code of Kenosha County. Submitted by Supervisors Molinaro, Eckerness, Clark, Elverman, Michael, Noble, and Brunig.
Supervisor Brunig.
Move ordinance number 17.
Ordinance 17 moved by Supervisor Brunig, seconded by Vice Chairman Eckerness. Supervisor Brunig.
Thank you, Mr. Chairman. This ordinance was brought forward due to the fact that we have always had map amendments that only took one reading. there was a question on it, so we have made the policy a little bit more clear to note that map amendments in the future will only require one reading. Thank you.
Any discussion on ordinance 17? Seeing no lights. All those in favor signify by roll call requested. P and plus if you're in favor, P and minus opposed. Motion carries 25-0.
Ordinance 18 from the Executive Committee, an ordinance to amend Section 8.02 Sub 5 and Sub D of the Municipal Code of Kenosha County, special event licenses.
Supervisor Michael.
Move ordinance 18.
Ordinance 18 moved by Supervisor Michael, seconded by Supervisor Eckerness. Supervisor Michael.
Thank you, Mr. Chairman. Basically what this ordinance does, it allows the Sheriff's Department and the Department of Planning to get information regarding establishments that are requesting to have a license for a day, basically. And previously, establishments were just able to pay $30. They'd get their permit, and this allows basically to make sure that these establishments are in compliance with the local ordinances. We've had issues with other, for instance, Club Climax in the past was able to, without having a cabaret license, get this license. And now this basically makes sure that an establishment is in compliance with all the local ordinances. So I urge your support. Thank you.
Any discussion on ordinance 18? Just a question, Supervisor Michael, if I can. The significant change to this was the requirement of a 3-business-day waiting period, is that correct?
Forwarded to the Sheriff's Department and the Department of Planning, because when an organization would try to get a cabaret license, they would have to go through all the hoops. But with this this type of special event license, all they would have to do is show up to the clerk's office, pay your fee, and they get the license.
And they get it the same day currently?
Correct.
Okay.
So this actually is the 3 days plus. It makes sure that the Sheriff's Department and also the Planning Department look into it to make sure that the establishments are in compliance with the local ordinances.
Thank you. Supervisor Clark.
The only question I have is, now you're getting planning and the Sheriff's Department involved. What if they don't respond in a timely manner? What's the
Corporation Counsel?
If they don't respond within the time period, then the license gets issued.
is that what this says in this policy, or? I just want it to be clear that there has to, that the Sheriff Department and the Planning and Development need to act within a certain period of time, or they're gonna forfeit their right to do that, and perhaps that is then reported to the Oversight Committee that there has been an application, they were unable to inspect, and so if we're gonna put this in place, we also have to not make it such a hindrance to business.
I think if you read D, and I'd have Corporation Counsel look at that as well, it states that the clerk is authorized to issue a special event cabaret license without further county board action unless the clerk is notified by the sheriff for planning and development that the premises are not in compliance with local ordinance.
It just didn't seem clear to me, and that's why I asked the question.
You could add the words within the 3 business day time frame. But I believe the intent there was that they would have up to 3 business days to look at the application, and they had that time to get back to the person who was looking for the license or the permit in order to tell them that there was or was not compliance. If they did not get back to them in time, then the clerk would be authorized to issue the special event permit.
So
Cabaret license, I'm sorry.
Because the way that I'm reading this is she's authorized to issue without county board action unless the clerk is notified from the sheriff or planning. So can we, where would you throw the 3 business day, right up in the beginning of that?
Unless the clerk is notified by the sheriff.
Unless the clerk is notified within 3 business days of a deficiency? I don't know, you've got that
Right,
part of it.
is notified within 3 business days by the sheriff or planning and development that the premises are not in compliance with the local ordinance within the 3 business day time period.
Right. So I mean, I would move that we have an amendment that starts that D that says unless the county clerk is notified within 3 business days by the, whatever the 2 departments are, that the county clerk is authorized to issue a special event cabaret license without further action, without further county board action, period. And then you can strike the rest of that.
What I would suggest, if I could, Supervisor Clark, second to last paragraph where the first 2 words are "and development." After the word development, you could insert within the 3 business day time period.
Perfect.
Then everything can remain as is.
Super. I accept that.
Supervisor Bruning, are you okay with that? Amendment made by Supervisor Clark, seconded by Bruning. We are now on the amendment. And I'll be flexible. Supervisor, lights are off. Supervisor Bruning.
Not on the amendment.
I see no lights on the amendment. All right, before you is the amendment, and the amendment is that after the words "and development" in the second to last paragraph, or sentence of paragraph D, and development within the 3 business day time period. That is what's being added. Everyone clear on that? Before you then is the amendment. All those in favor of the amendment proposed by Supervisor Clark, seconded by Supervisor Bruning, signify by saying aye. Aye. Those opposed? Motion carries. Before you now is Ordinance 18 as amended. Supervisor Bruning.
Thank you, Mr. Chairman. I have a question regarding the fee on here. If we are now incorporating 2 other departments into this process, I'm wondering if maybe the fee should be higher. Because now you have 2 departments that have to go make visits to the site. I guess I would make an amendment to increase the fee to $50.
Motion made by Brunig to increase the $30 fee as it's currently stipulated to $50, seconded by Vice Chairman Eckerness. Anything further, Supervisor Bruning?
No.
Anyone on the amendment before you? Supervisor Hallman.
Thank you, Mr. Chairman. I'm not opposed to increasing the fee, but I'd certainly like to know from Planning and Development, as well as the Sheriff's Department, what the cost actually is of doing those inspections so that we can have an accurate number. Thank you.
Anyone else on the amendment before you? Increase of the fee from $30 to $50. Seeing no lights, all those in favor of the amendment signify by saying aye. Aye. Those opposed? Motion carries. Before you is the ordinance as amended. 2 amendments are the fee and the notification within 3 business days. Anyone on the ordinance as amended? Seeing no lights, we'll roll call. If you're in favor, P and plus. Opposed, P and minus. This is the ordinance as amended. Anyone need it reread? Motion carries 24-1.
Ordinance 19 from the Planning, Development, Extension, Education Committee regarding Richard E. Sr. and Carol Flocker, owner, Doug Hughes, agent, requests a rezoning from R4 Urban Family Single Family Residential District to R4 Urban Single Family Residential District and C2 Upland Resource Conservancy District in the town of Salem, submitted by Supervisors Brunig, Kohlmeyer, Decker, and Gable.
Supervisor Brunig.
Move ordinance number 19.
Ordinance 19 moved by Supervisor Brunig, seconded by Supervisor Kohlmeyer. Supervisor Brunig.
Thank you, Mr. Chairman. This property is located on the northeast side of County Trunk Highway SA, approximately 0.04 miles northwest of 272nd Avenue. The rezoning would allow for a small piece of land containing the west side of the Center Lake Dam to be transferred and attached to the Camp Center Lake Rehabilitation District, providing full ownership and access to the dam. The Town of Salem recommended approval of the request, and I can attest to the fact that this has been a thorn in our side for many, many years. There has been constant fighting over this dam and who is going to maintain it. The Town of Salem is very happy to finally have this put behind them, and we'd like to move on with it. Thank you.
Thank you. Anyone else on ordinance 19? I see no lights. All those in favor of ordinance 19 signify by saying aye. Aye. Those opposed, motion carries.
Policy resolution, second reading to required. Number 5, from the Executive Committee, a policy resolution to create a contracting policy for Kenosha County.
Supervisor Clark.
I move policy resolution number 5.
Policy resolution 5, moved by Supervisor Clark, seconded by Supervisor Eckerness. Supervisor Clark.
Thank you, Mr. Chairman. This policy has been 8 years in the making. This is a new policy to Kenosha County. I think the issue came up many years ago when I was on the administration committee. Brooke Coons made a report to the committee and then sent us a letter later that week and said, oh, by the way, we decided to contract dental contract without bidding it and all these various different things. So it just raised questions. This is not the purchasing policy, but rather the contracting policy. It talks about the format of the policy. Frank's office went through, it codifies really what's already being done in a lot of cases for our social services contracts. There's certain contracts, they have certain formats. Frank goes through and approves the formats. They're going to build on the website or within their system standard contracts for the various different things that we enter into that are approved contracts. This sets the level of contracts that need to have Corporation Council approval to $50,000. There's a table in here that really talks about who and where the approval is required. Is it a county board function? Is it a county executive function? We spent time with the administration going through this, had a lot of discussion and debate about it, looked at current state statute to make sure that we are in compliance. Also, we spent a lot of time on contracting policies, or not contracting, but when we're in the, for example, building, safety building. And we talked about change orders and or bid alternates, and when those items need to come back to the committee. There's certain time frames that are put upon the county board to act on change orders if they meet the threshold and the criteria. And I think, you know, this is our first shot at it. It's taken 8 years to get to this point. It did come to the county board about 4 years ago. There were some issues with it. It was sent back. We've struggled to get through this. We do have it done, and certainly as time goes on, this may not be. There may be additional changes that are needed. Hopefully, future county boards will review the policies. One of the things that came out of the executive committee is we also need to start looking at all our policies, but we want to take a look at the purchasing policy as well. So I urge your approval, and if there's anything the Corporation Council would like to add relative to this.
No, I think that this is a good policy. I think that it clarifies who has the authority to enter into these contracts and execute them. Parenthetically, I just was up in Milwaukee last week on a contract, and that was one of the first questions and one of the first issues that came up, and who has the authority to sign this contract. So I would urge you to do this. If issues come up in the future, if we miss something and something needs to be added or modified, I would recommend that you work with this for a year or so and see if anything needs to be tweaked, but I think that you should have it. It clarifies where the boundaries are and who gets to do what. It also has an appeal process in there for people who are have a complaint about a bidding process or an RFP process. That's another thing that I think is important. should go a long way toward expediting the flow of contracts so that we don't have to spend, hours just trying to look at contracts that are form contracts and that we've already approved.
Thank you. Anyone on the issue? I see no lights. I want to take the opportunity to thank Supervisor Clark for staying at this issue, the entire executive committee, certainly Corporation Council for staying on task with it, the administration, County Executive Cruiser had a great deal of input, Director of Finance, Geertsen, Director of Purchasing, Ms. O'Neill, came in a little bit nervous at the last minute, I think, or towards the end anyways. I appreciate all the input from everyone that was involved in it. I think we have a solid policy in place, one that will allow us, as Supervisor Clark pointed out, to continue to execute projects, put out bids, receive proposals under what I think is a very fine system, a very tight system currently that is administered not only by Ms. O'Neill but also Mr. Arbit and the way that Kenosha County executes the projects that we execute. So this, in my mind, is a help and will go a long way to codifying what we've been doing already and setting the stage for the future. So with that, all those in favor signify by saying aye. Those opposed, motion carries.
Number 6 from the Finance Administration Committee, a policy resolution to reclassify one position in the Sheriff's Department from office support worker to office associate, submitted by Supervisors Clark, Eckernus, Jeff Gentz, Grady, O'Day, Singer, Rose.
Supervisor Clark.
I move policy resolution number 6.
Policy Resolution 6, moved by Supervisor Clark, seconded by Supervisor Grady. Supervisor Clark.
Policy resolution number 6 is a bit of a house cleaning measure. Back in, I believe it was 1996, when they set up the non-rep pay plan, they went through and they classified employees in the various different classes or throughout the county. It was actually non-rep, but throughout the county. And at that time, we ran into a situation where we had an employee that was paid at one level, but met the lower grade of the office support worker. So the agreement with the union was that once this person retired, which at the time of doing the budget it wasn't known, but once this person retired, that this position would then be properly classified. This is more of a retitling of a position, as this person over time, or this position, has taken on more duties, and this does not have a financial impact because the person may have been classified at this level, but they were paid at the level that they were and continue to have their growth. So it's essentially what we're doing here tonight.
Anyone on the question? We are on Policy Resolution 6. I see no lights. All those in favor of Policy Resolution 6 signify by saying aye. Those opposed, motion carries.
Policy Resolution 7 from the Finance Administration Committee, a policy resolution to reclass the stock person position to a shop operator.
Supervisor Clark.
I move policy resolution number 7.
Policy Resolution 7, moved by Supervisor Clark, seconded by Supervisor Jeff Gentz. Supervisor Clark.
In Kenosha County Department of Public Works, Division of Highways, currently we have a stock person position, and management has deemed it appropriate to reclassify that position as a shop operator, expand the duties or get more out of one person, and assume the responsibilities of the stock person. The shop operator, almost as I was reading the memo, is almost like the guy who coordinates the service in a service garage in a gas station. You have the service manager. We are getting into more software and tracking vehicle maintenance and how vehicles are being used and all those various different things. And this person is also going to be responsible for tracking maintenance, setting up that program, and coordinating and scheduling the workflow to the mechanics and whatnot, what needs to happen in that in the shop. So from management standpoint, it is a efficiency move, and within the current year, it fits within this budget. There's no budget modification other than a reclassification.
Thank you. Anyone on Policy Resolution 7? I have no lights on the board. All those in favor signify by saying aye. Those opposed, Policy Resolution 7 passes.
New business ordinance, first reading, 2 required. 20, from the Redistricting Committee on an ordinance related to amending Chapter 1 of the Kenosha County Municipal Ordinances related to supervisory districts, submitted by Supervisors Eckerness, Clark, Decker, Michael, O'Day.
Vice Chairman Eckerness.
I move that we suspend the rules to allow consideration of this ordinance this evening.
Motion to suspend the rules by the Vice Chairman Eckerness, seconded by Supervisor Clark. Anyone on the issue of suspension of the rules?
The purpose of doing this is...
Hold on. Supervisor, sure, go ahead.
The purpose of suspending the rules is to allow action tonight so that the clerk can proceed with preparing the ballots for the upcoming spring election. If we don't deal with this tonight, there will not be enough time to get ballots prepared so that people can vote absentee.
Supervisor Elverman, I'm sorry.
That answered my question.
Thank you. I have no other lights. On the issue of suspending the rules, all those in favor signify by saying aye. Aye. Those opposed, motion carries. Vice Chairman Eckerness.
I move ordinance number 20.
Ordinance 20, moved by Eckerness, seconded by Clark. Vice Chairman Eckerness.
All right. The reason for this ordinance change is because during the redistricting process, the city failed to provide for a 5 blocks, census blocks, to be in one of their wards. The easiest fix for this problem, which was their screw up really, would have been for them to create another ward. They chose not to do this for whatever their reasons are. A little history: before the redistricting, the city had 62 wards. After they lost in court, they chose not to follow the judge's recommendation, and instead they created 79 wards. They were asked if they would create one more ward to take care of these 5 census blocks here, and they chose not to do that. However, last night they created 9 more wards to accommodate the assembly district provided for by the state. This is a mistake that the city made. Granted, it was overlooked by our staff amongst all the confusion that was going on around this issue at the time. It was discovered several weeks ago. An effort to resolve the issue with the city was met with failure because of the city's failure to cooperate. Therefore, their only fix is to attach 139 people to district number 4. It makes a ugly looking district, but we don't have any choice. Thank you.
Thank you. Supervisor Clark.
I just want to take the opportunity once again to thank Al Brockmeyer and his staff. This oversight, if you want to call that, was we got the judgment from the court, and there was a last-minute scramble by the city to get their map, and they decided to change their map and make it compliant with our supervisory districts. So certainly those things happen when you're working under the gun and you don't have the time to review. I think his department did an excellent job throughout this process. Thank you.
Thank you. Supervisor Grady.
Thank you, Mr. Chairman. I had the pleasure of Mr. Brockmeyer in my place of business Monday morning. He outlined the situation that exists adjacent to my first district, asked me if there was any concerns I had and if I was open to this solution that we're discussing here tonight, and I assured him that the solution we've arrived upon is fine, so I think we're able to proceed, and I have no reservations. Thank you.
Thank you. Supervisor Gable.
This basically affects my district. I was representing about 4 blocks in that area before. All this does is give me more doors to knock on, more people to talk to, and I'm fine with that.
Thank you. I have no other lights. Mr. Brockmeyer, if I could promise you this would be over soon, I would. Anybody's guess, but I appreciate the effort once again. No other debate. All those in favor of Ordinance 20 signify by saying aye. Those opposed, motion carries.
Resolution, one reading, 106 from Human Services Committee, a resolution to approve the appointment of Linda Gacci to the Kenosha County Aging and Disability Resource Center Board, submitted by Supervisors Noble, Jeff Gantz, Celebrity, Arrington, Decker, and Kubicki.
Supervisor Noble.
I move Resolution 106.
Resolution 106 moved by Supervisor Noble, seconded by Supervisor Celebrity. Supervisor Noble.
The Linda Gashi came before the committee and was interviewed by the committee. She's very familiar with the Division of Aging and Disability Services, and she's previously worked with that department for many years, and she's worked in home health care and has had much interaction with that office. Currently, she works part-time in Aurora, and she will be representing Aurora on the board. So we unanimously supported her for this committee position.
Thank you. Anyone on the question? I have no lights on Resolution 106. All those in favor signify by saying aye. Those opposed, motion carries.
Approval of the February 28th, 2012 minutes by Supervisor Esposito.
Supervisor Esposito.
Thank you, Mr. Chairman. I'd make a motion to approve the February 28, 2012 minutes.
Motion made by Esposito, seconded by Hallman. Any discussion? I have no lights. All those in favor signify by saying aye. Those opposed, motion carries.
Possible closed session per Wisconsin statutes 19.85 sub 1 sub G, consultation with attorney regarding pending litigation, status of Kenosha County versus City of Kenosha Health Department litigation.
It is my understanding there is no need to go into closed session. Is that accurate, Corporation Counsel?
Yes, there is no settlement.
So at this point, I'll allow Frank to give a brief report, update on where things sit, if he's inclined.
Thank you, Chairman Molinaro. As you know, approximately 3 or 4 weeks ago on February 9th, the last thing that had happened in this case was a scheduling conference. That was postponed at that time till toward the end of April, I believe April 22nd or 23rd, as I recall. Yes. And the reason for that was that we had reported to the court that we thought we were close to a settlement. It's my understanding that there had been some agreement between the county executive and the mayor. The mayor at the meeting last night took it to the Common Council and apparently did not get support for the proposed settlement. Nor is he, it's my understanding, putting that on the Common Council agenda for action by the full council at an open session. Our office filed a motion for a partial summary judgment on February 9th. I was hoping to have that argued approximately 2 or 3 weeks after that, while I was still in a position to argue it. At that time, that motion was also put off to be rescheduled at the time of the scheduling conference in the middle of April 22nd or 23rd. My motion had asked for a summary judgment on the 9 counterclaims that had been commenced by the city against the county. Those counterclaims deal with allegations that we have breached a fiduciary duty, that we are being unjustly enriched, that they are entitled to an accounting, that the contract should either be rescinded or reformed, in other words, modified, and I believe there's one other issue that, well, the tax equity issue. Also, those counterclaims were amended approximately around the first of the year to include some allegations that there was a violation of the state constitution with respect to uniformity of taxation. We've looked at all of those. I filed a brief. It was 70 pages long. We put an awful lot of effort into it. I believe that the county is in a strong position to defend on those. I've asked the court to issue summary judgment, which in effect means that there are no material issues of fact, that just questions of law, and that those 9 counterclaims should be dismissed with prejudice. The other thing that I had filed at that time, which I indicated I would later file with the court, was a motion for sanctions because, in my opinion, the 9 counterclaims were without merit and, in fact, frivolous. In fact, they are asking that the contract be nullified going back to 1993, asking for monetary damages way beyond what they would be entitled to under the law. I have pointed out that they failed to file a notice of claim. They will probably argue that we had actual notice and we're not prejudiced. I believe I've answered that and shown just the opposite. There are statute of limitations issues and equitable principles. For the lawyers in the audience, they'll recognize the concept of latches, which means they've just haven't done anything for the last 19 years and they're basically a day late and $1 short. As things stand right now, I don't know where those negotiations are between the mayor and the county exec. I don't believe there were any communications today. The fact of the matter is that with my leaving now, there is an issue with respect to representation by the county, for the county. If in fact it does become necessary to retain outside counsel and the motion for sanctions is granted somewhere down the line, those costs could be recouped with respect to these 9 counterclaims. As you know, the cost of outside counsel can be quite heavy. So I am hoping or hopeful that this will resolve itself and that the county and the city can start anew, if you will, and approach some of these issues in such a way that we can get beyond the monies that are owed. If in fact that there are items which the city wishes to negotiate, renegotiate in the IGA, they certainly will have that opportunity to do that. I think the county executive has indicated that he's open to listening to whatever their concerns are and attempting to address them. I am satisfied that the issues with respect to uniformity of taxation, I believe, are without merit. I believe that the issues with respect to tax equity, once we get into the explanations of how the IGA worked, I think that that testimony coming from Mr. Geertsen will go a long way toward dispelling a lot of the confusion and misunderstanding that may have resulted. I believe that this contract is in the best interest of both the city and the county, and I think that if given the opportunity to review some of the observations by Mr. Geertsen, I think a lot of those issues would be answered.
Supervisor Rose.
I think we should retain Mr. Volpentesta as the private counsel, and would urge you, Mr. Chairman, and the county executive to discuss that with him, since he is retiring and he knows the case best, and I believe would do the best job and most efficiently. Second, we should proceed without any further negotiations. We have talked with the city for years. This whole health department issue came up first under the administration of Alan Keel as county executive, and here we are concluding the term of Mayor Bosman, and it's still out there. They will talk you to death. So I think we need to have the case presented, argued, and decided. Everybody lives with the end result, the city and the county. And the third thing, in light of this, I would certainly urge the county executive to withdraw the appointment of Mr. Passetti to the Workforce Development Board. I think at this time it would be unnecessarily divisive and contentious and embarrassing to proceed with that.
Thank you. Corporation Counsel.
Yes, if I could just comment on your first observation or request. I am not able to do that for a variety of reasons. The main one being that under the law I cannot collect retirement and still be employed by the county or arrange for employment ahead of time. I've indicated that I am more than willing to come back and argue at no cost to the county the motions that I currently have pending. That's not a problem for me. The work has been done, and it's simply a matter of coming to court and making the argument. There's probably also some ethical considerations, I think. I don't want to be in a position where I am using my position here in my retirement to solicit work. Again, I don't have any problems doing this as long as it's understood that there's no charge, and that if it goes beyond that, then I think probably at that time there should be some serious consideration toward going with outside counsel.
Vice Chairman Eckerness.
Thank you, Mr. Chairman. This is kind of an upsetting situation. There was a contract that was negotiated and entered into between a previous county board and a previous city council that took action by the city council and the county board all those years ago. Somewhere along the line, there was a decision made that they didn't like the contract. The council did not take action on that decision, yet the administration, the city administration, somebody over there decided we're not going to pay that much, we're not going to pay them anymore. This is a simple contract law thing. I don't understand what kind of legal advice they get over there that would allow this situation to deteriorate so much. They've created a situation where I would hope that this board, I won't be on it, but I would hope that this board in the future will not even consider cooperating with the city in contracts of this nature, because this is what you can expect. This isn't the only issue that we've had with the city over these agreements we've had with them. We see editorials. We see voters and a voice of the people. We should consolidate government things, you know. Well, how can you work with people that are like that? Now, it's my understanding they're not even going to the council on whether or not they should settle this thing. This is being done with the administration. And it seems to me the city administration over there has decided that the council is unnecessary in this when they were the ones that signed the contract that created this partnership to provide the health department services. So I agree. We should not negotiate with them one more minute. We should go directly to court like we did with the redistricting and have it decided properly by a judge and be done with it. The more you discuss it with them, the longer it gets dragged out. Not unlike the Iran nuclear thing. So, thank you.
Supervisor Jeff Gintz.
I would concur with Supervisor Rose and Supervisor Eckerness while he was talking about the issue. We need to just go to court, set the dates, and move forward. I mean, I can appreciate wanting to work things out, you know, between the mayor and the executive and spare the public this whole thing. But if you don't have two parties that are going to work together, you need to have some guidelines and some drop dead dates. And so, you know, I think we need to get to court, and that's the date. And I don't think we should continue down this road. We should set these dates, move forward. If they can put something together and stop it, that's great. But at this point, I don't think we should delay anything. So, thank you.
Supervisor Clark.
Thank you, Mr. Chairman. First of all, the mayor and the county exec, I want to thank both of them for getting together and trying to resolve and settle this issue. I think they had a handshake agreement, and the county executive, you know, has talked to, updated the chairman, updated me as the finance as to where they were, what was the tone and the feel of the board, and you know, they came to a point where we were saying, yes, we'll settle for $34,000 less than we're entitled to. We'll avoid the cost of litigation. We'll quit wasting the time of our corporation counsel, who has many more important issues to deal with. And so I want to congratulate them. The mayor, you know, I understood the deal. I called the mayor and said, I just want to confirm, after I found out it fell apart, I just want to confirm that this was the deal and this is what happened. And here's the deal. The deal was, there's no disagreement that they owe us about $551,000. That's the issue, whether you owe us or not. The issue isn't whether we should be in the health department contract or not. That's not the issue. They're trying to throw other issues in there. We had an overpayment from 2010 of 140-some thousand. We wrote a letter to the city and said, we're going to keep that. We had an overpayment, or when we did the accounting, because the county was more efficient and saved money. We saved money, and so we used our savings to offset what they owed us. We're estimating about another $70,000 in savings for 2011. We said we're going to offset that. That left it at about $334,000, somewhere in that neighborhood. The deal was, okay, guys, we'll take $100,000 over the next 3 years. When you study our county board budget, or if you remember the county board budget, there were substantial savings in the health department in the levy from going from 11 to 12 because of the efficiencies that have been gained within that department, and they've saved substantial amount of money. There was an agreement to give them the ability to be at the table in the budget process relative to that department. The executive and the mayor came up with a good deal. The mayor, as he said, in an informal meeting with some of the members of his council, I'll assume those are the leadership of the council, and you all know who they are, they said, no, what are we going to get? What are we getting? You're getting $34,000 less. You're saving the taxpayers the cost of litigation, but they're saying, no, what are we going to get? We got to get more. They're clouding the issue. I don't think we need to hire an attorney. This is a simple issue. You owe us, here's the contract, pay it. We've given something. The executive said, you guys want to talk about the contract. If you don't know what the issue of the contract is, after we entered into the contract, the state law was changed saying that the counties are responsible for the health departments. There's things above and beyond that we could charge them for, but there was a state law change. So the executive has said, look, yes, we're willing to look at this, but first things first. Pay us. We'll talk about the next issue. This went back to Mayor Antaramian and Alan Keel. At that time, I've advocated going to arbitration. For those of you that have been around, you recall that there was an issue with joint services. We had the issue about how much, what percentage should they be charged? In a meeting in the executive's office back then, you had the mayor, you had Keel, you had the city attorneys, the corporation counsel, the various different people. I was in the room, and we agreed at that time on a handshake. We're going to go out and get a study. We're going to agree to who's going to do that study, and we're going to accept the results, whatever they are. After we walked out of it, the mayor and the executive got together and said, we need to throw one more caveat in there, and that's we're going to phase in whatever change it is, and we had no idea which way it was going to go. We're going to phase it in so it did not impact one or the other's budget significantly within 1 year. That study came back. That study did not go to the advantage of the county. We had no written agreement. No written agreement. We had a new executive, we had a new mayor, we had a new administrator, and there was some dispute about what was said, what was actually done. At that time, I said we need to get it in writing. It never happened. I was called into the meeting to somewhat mediate what really happened with the two different administrations. We got to that point. I said we need to do a sidebar. I went to our county executive. I went to the finance director, and I said they're right. The city's right on this one. It went against us, and in fair play and on a handshake, we honored that deal, and we're honoring that deal today on a handshake. For 7 or 8 years, we're picking up $75,000 more in a cost shifting from the joint services. We did that on a handshake. We've offered to go to arbitration time in and time out, and the city has refused. They would rather spend money on attorneys. It cost them in the Bear Development thing. It cost them in the redistricting where they lost. And it's going to cost them here. And who's losing? The taxpayers. In the nonsense, I think in response to our filing suit, we filed suit to protect our position because the claim was so old. The statute of limitations was going to run out. So unless we filed suit, we're going to lose our right to the money that we were entitled to. It wasn't because we're trying to push them in the corner or be the bully on the block. We were protecting our position, and that's what you do in business. That's what you do in sound government. Going back to the nonsense, I think when we filed the suit, I think there were over 805 inquiries or response for information from us. It was over 800, correct, Frank?
878.
And that was for what?
They call that demands to admit or deny particular allegations.
878 allegations by the city attorney. 878 on something that simple. And we're going to go to court. You have the leadership of the city council, you know who their committee chairs are, saying, what are we getting? They're forgetting about the taxpayers. That's who's getting screwed here. One other point, tax equity, for those of you that have been around here for a long time. Tax equity issue comes up all the time. This is no different in cherry picking on tax equity as well. City of Kenosha represents 59% of the county population. In apportionment, they pay 43% of the levy. And they always like to point to, well, Sheriff Patrol, we have no Sheriff Patrol there, but let's talk about the jails, let's talk about the courts, let's talk about human services, and let's talk about those needs. You want to talk about the highways? Without those highways, you don't have the traffic, the ability to come into the city. So, to the mayor, I say thank you. To the mayor, I say show leadership. To the mayor, I say you put this in the city council's lap. Let them vote on the record, in public, up or down. You want to finish it? You want to save the taxpayers' money? Put the city council on the spot and have them make a decision. Thank you.
Thank you. Supervisor Holman.
Thank you, Mr. Chairman. I too want to thank the mayor and the county executive for trying to come together to broker a deal. In an attempt to de-escalate this a little bit, whenever we discuss this, I feel a little bit like we're watching Dr. Strangelove and we're in the war room. I can appreciate the sentiments of wanting to go to court. I think that there's good merit for doing that, as folks have outlined. But I would wonder, with elections coming up, if perhaps conversations that our current members would have with those who are looking to be soon to be members of the Kenosha City Council, to make them aware of this issue and give them a chance to do the right thing where previous councils have not. I think that might be wise to do that, legislator to legislator, before we rush in taking them to court as quickly as our feet, our hearts, and our heads might seem to want to move us. Thank you.
Thank you. Vice Chairman Eckerness.
The time for diplomacy is at an end. It has gone on far too long. It's time to pull the trigger. Take them to court, and that's that. Let the judge decide. They were able to decide. The judge was able to decide in the redistricting and other issues. We shouldn't have to put up with this kind of thing. So, thank you.
Supervisor Rose.
Could we, I ask the Corporation Council, pass a resolution incorporating what Supervisor Vice Chairman Eckerness and I have suggested, and that is we proceed with the litigation and end negotiations? Is it appropriate to make such a resolution?
The motion is treated as a resolution.
All right. I would move that we direct the Corporation Council to proceed in accordance with law with his various motions for summary judgment and trial if necessary, and that negotiations be terminated.
Second. Moved by Rose, seconded by Eckerness, to proceed with all haste to filings in court as necessary, I guess, as law provides. Is there any further discussion on the issue? I have no lights on the Supervisor Jeff Gentz.
I have a little bit of a question toward the second part of his motion. Ending negotiations, does that preclude the mayor from putting it to the city council, or the mayor and the county executive from working it out prior to the court date? I mean, is that the intent of the motion?
Supervisor Rose, you want to address that?
No, I think the motion speaks for itself, and I don't think anything more needs to be said.
Then please read the motion back.
How about
that's what we have a clerk for. She can read it.
No, I wasn't asking you to. Somebody.
All right, the motion before you is to direct Corporation Council to file the appropriate briefs and court filings, as well as proceed to a court hearing as expeditiously as possible. The second part of that is to terminate all.
The motion was to authorize and direct the Corporation Council to proceed with the motion for summary judgment and trial if necessary, and terminate any and all further negotiations.
Just for anything else? Jeff?
Yeah, I'm going to vote against that. Okay.
All right. Just for the record, I sat through an awful lot of the redistricting hearings, and there isn't a judge in the Kenosha County, I wouldn't think, who isn't going to urge us daily, if not repeatedly throughout the day, to come to some settlement. So I put that out there because it is exactly what will take place. Supervisor Ron Frederick.
Mr. Chairman, I don't think I'm going to support a resolution to terminate anything. We're in litigation right now. I mean, it's going to go forward if we can't come to an agreement. So what do we need a resolution to suggest that we're going to terminate and not talk to them again? If there's a chance, any chance, I think we should go ahead and just keep it going or whatever it is. I mean, what happened here tonight was you know, for me, it just, I can see the headlines tomorrow. I don't think it's gonna, we probably won't have to have a motion to terminate it. It'll probably be terminated, because when they start reading the paper tomorrow and everything that was said here tonight isn't gonna be pretty tomorrow. So I'm not gonna support a resolution to stop anything.
One would suspect there'll be very few surprises when anyone reads the paper. Supervisor Clark.
I'm not going to support the resolution. I think we've already authorized somewhere in the process Frank to proceed to court, or whether it came through committee or whatnot, but there was one authorization. We're in that process. I want to give the administration, for whom this lies, the responsibility, and I want to allow our Corporation Counsel's office to follow the legal procedure, the legal strategy that they choose to follow. What I want is, I want this resolved quickly and without further cost.
Thank you. Supervisor Michael.
Thank you, Mr. Chairman. Clearly, I agree with Mr. Clark, Supervisor Clark, as a supervisor that represents an area that's in the city of Kenosha. It's very upsetting that the city council is acting in the way that they are, but clearly I cannot agree with Supervisor Rose's resolution regarding ending negotiations. I'm hoping that the mayor and city council will come to their senses and to think about how this is truly affecting the taxpayers of this community, and they act rationally, and hopefully they can resolve this issue. Thank you.
Thank you. Supervisor Rose.
This resolution tells the city that negotiations have ended. An agreement was reached, put it on the council agenda, and approve of it. We have the contract behind us. What they are looking for is further negotiations. This issue has been studied to death. We had professionals who came forward and issued a report on the allocation between costs between city and county, and that was under Executive Keel. There really isn't anything further to talk about here. This resolution doesn't preclude the city council from approving the negotiation agreement that has been reached. I would hope they would do so. They're looking for other they're looking for other concessions through further negotiations. If you understand the issue, there's no need for that. They're just being obstreperous. You're making a big mistake by defeating this resolution. They will talk you to death. This proposal, this discussion has been on the table of the agenda of the city and the county for at least 4 to 5 years. If you want it on the agenda for an additional year, 2 years, then defeat this resolution. But what this resolution tells them is negotiations are over. There's a reasonable proposal here that has been reached between the mayor and the county executive. Adopt it, and let's get on with things. But to defeat this resolution, you're telling them, oh yes, we'll concede some further points. We'll give you something else. The city attorney, as Mr. Valpentesta has said to you, has submitted to the county over 800 interrogatories, questions, which he had to sit down and respond to, answers. That's discovery. All that is done, that was done to delay. That was done to harass, to make his job more difficult. And what I'm suggesting is, let's end those kinds of negotiations and that kind of nonsense that we are getting from the legal team at the city and what we are getting from the city council. When I say end negotiations, I mean the negotiated agreement that has been reached by the executive and the mayor should be approved and placed on that county board, that city council agenda, so that we can end it. Don't get yourself involved in other negotiations where there are going to be further concessions on the table, further interrogatories issued by the city attorney to the county. Let's get on with things. Support this resolution tonight.
Thank you. Supervisor Jeff Gintz.
Thank you. See, that's to Supervisor Rose's comments. That's why I asked to have it read back. Now what he's saying is a little bit different than what I interpreted at first. You have to understand not all of us are attorneys. We all come from different areas in life, different backgrounds. And I mean, if he's saying let the negotiations stand and let what we have worked out continue to fruition, that's different than end everything and go to court, in my mind. So, you know, I would also ask for some clarification through the chair to the Corporation Council. Do we have dates set to continue this process in court?
On April 22nd or 23rd, whatever that day is, the judge will set dates. He will set a date for discovery, a date for motions, date for summary judgment, date for a pretrial report, and a trial date.
So whether we approve anything about continuing to court or litigation or
We're in
filing
court.
anything, it's already going on,
Yeah,
correct?
it's already in court, and the judge will assign dates and parameters toward the end of April.
Okay. So nothing we can do would change what's already in the system?
No, you've given authority to start
Okay.
the litigation, and I've done that. And as far as the negotiations, it sounds like what you're trying to say is that the parameters of negotiations have been set, and those are what has already been negotiated between the mayor and the county exec, and that's basically pay the bill. If they want to still accept that, you know, that's the end of the lawsuit. I mean, if they accept that, that's the end of it.
Okay. Thank you for that clarification.
Is that it? Supervisor Singer.
Thank you, Chairman. I, for one, do not want to stand on the hands of the county executive, okay? I do not want to stop his ability, and I don't think we can, as a county board, dictate to the county executive what he can and cannot do, okay? We just did a policy thing tonight indicating what the county executive can do and can't do in contracts, okay? So I'm not going to go there with this one either. I think Supervisor Rose is right, though, is we need to stand behind what was agreed. And that's the resolution we should be talking about, is the resolution on the agreement, okay? Saying that we as county board supervisors agree with this, okay? Maybe the city council doesn't agree with it yet. We don't know. They haven't taken the vote. You're talking about a meeting of some of the heads. Let's be positive. Let's bring this thing and bring a solution to this rather than a fight, okay? Let's stop the rhetoric. Let's stop that. We know we're going to court if nothing happens. There's going to be specific dates. It's going to go down. Let's work on a solution, guys. That's what we should be doing.
Thank you. Vice Chairman Eckerness.
We need to put their feet to the fire. The only way you do that is follow a firm schedule. If the county executive wants to talk to the mayor, that's fine under this motion as I see it. But in no way whatsoever should any of the court proceedings be delayed because they want to keep negotiating. If it comes to that April date and they say, well, we're close, can we extend it another 2 weeks? The answer from this board unanimously, hopefully, absolutely not. You've had all this time to do it. Now let's get it done, because you see this in lawsuits all the time, where you come up to the date there and, well, you know, we're so close, and then it keeps put out a month, put out another month. Oh, we're close. That's where we've been all these years. That's where we have been all these years. Put an end to it. It's time to stop being the nice guys. Diplomacy has not worked. Vote for this. If the county exec can bring them to vote on it in chambers and accept this deal, which is a sweetheart deal, how much money have we spent pursuing this thing? We're giving them a $34,000 discount, and how much of your office's time have we got in dollars and cents?
I have been keeping track of my time, so I do have a timesheet. And it is considerable. We've been doing this since, this has been keeping me pretty busy for the last 6 months.
The message has got to be, from all of us, that we are mad as hell and we're not going to take it anymore.
Supervisor Clark.
I won't belabor the point, but City Council did meet on this Monday night. I have something from the Kenosha News, who is always right. It says the council was to discuss the issue on Monday night. The only thing that came out of Monday night is that we will look at other options of settling the suit, said City Council President Jesse Downing, who was challenging Bosman in the April 3rd. We are trying to figure out the best way to resolve this for the taxpayers. Alderman G. John Ruffalo, we will continue to negotiate with the county's elected officials. And here lies the difference. The county board has entrusted the executive. The city council does not trust the mayor. They won't let the mayor do his job. They won't let the administration do their job. April 22nd is about scheduling time to screw the taxpayers more. So, I agree with Supervisor Singer. We shouldn't be, I'm not going to vote for this resolution. We want to vote for something. Let's vote that, let's have an amendment or a resolution that says we support the county executive's efforts to resolve this, and that applying the 2010 and 11 overpayments and settling for $300,000 where the payments are $100,000 over the next 3 years is what we support.
Supervisor Gable.
This has been going on for years. Hopefully, April 3rd, April 4th, we'll have a new city council. Maybe then, we've got to keep negotiating. We have until the 22nd of April before we take them to court. We got to talk to them. Things may change between now and the 22nd of April. We can't quit talking to them. That's just losing.
Thank you. Supervisor Gail Gintz.
Thank you, Mr. Chairman. I believe that this board made the commitment when we authorized the lawsuit to begin the lawsuit. So I don't see that this resolution is necessary to give direction as to continuing the lawsuit, because the lawsuit's going to continue anyways. I'm not in favor of stopping negotiations. I think that any time any lawsuit has been filed, negotiations continue through the entire period of the lawsuit, up to the last minute. So should we hold their feet to the fire? Certainly. I think that I think our attorneys have that ability. I would hope that the judiciary, when they set their court dates and set those types of things, that they understand that this has been dragging on for a long time. I know there are certain time periods for discovery and those types of things that you have to do. But I do think that at this time we need to continue with negotiations. I would certainly support Supervisor Clark's resolution to, if he would like to make that, I think that that would be more in place, that we would support the county executive and direct him to continue that negotiation, and certainly to try to force, or not force, but to acknowledge that this is a good solution to a problem that's been pending for way too long. Thank you.
Thank you. Supervisor Overman.
Thank you, Mr. Chairman. I was going to stay out of this because it's reminding me so much of our last meeting. I think we've saved our goofiness to the end of our meetings, the last two. What are we sitting here talking about? We had a report from Corporation Counsel. We know the trial dates. We know everything that's going on. We know the county executive has been talking to the mayor. amendments to amendments on these resolutions, none of this is even on our agenda for this evening. Why don't we let the court follow its course? If we want to pass something that says we're not going to talk anymore, it's not going to carry any weight with the county executive. His job is to try to work this out, and he's going to continue doing that. We can't tell the county executive he can't go meet with the mayor. All this is just like last meeting, where we're sending a resolution to the state legislature that's not going to look at it, and we sat and made amendments for 45 minutes. I guess everybody needs to talk on this tonight, but it's going nowhere. Thank you.
Thank you. Supervisor Rose.
Move we adjourn.
I understand that. I'm just surprised. Motion by Rose to adjourn, seconded by Decker. All those in favor signify by saying aye.
Aye.
Those opposed? Thank you all. Enjoy the evening.